was appointed, and she's been on the bench for about 20 weeks. I'm here to tell you that you have a choice on April 2nd to choose your judge, and I'm going to tell you about me and why I am the best choice. Before I talk to you about my experience, I want to talk to you about who I am. I grew up in northern Wisconsin. I've been a lifelong resident of Wisconsin. My parents had elementary school educations, and I learned early on in my life that people without voice, without sophistication, and without education get left behind. And I decided when I was a little kid watching that I was going to be someone to give people a voice. And the best way that I thought to do that was to be a lawyer. Now that was a pipe dream for me as a little kid because I grew up in poverty, but I used public schools. I went to public schools my whole life. I put myself through college and law school, and I became that voice. I went to law school right here in Dane County at the University of Wisconsin, and I graduated as editor-in-chief of the Law Review, which opened a lot of doors for me. I was drawn to personal injury law, which is what I do now, because I got the opportunity to represent real people in real court. I got the opportunity to give people the voice that I wanted to give them, because in my mind, justice is for everyone, not just for people who can afford it. And I decided that was what my career path would be, and that is what I've been doing for 16 years. I want to talk about my experience and why I want to lend my voice now to the Dane County bench and my experience. I've been practicing in Dane County my entire career, almost 17 years. I have been at the law firm of Cavish, Hadish, and Rotier, where I have represented people in court day in and day out in trial court. Now that's important because my opponent has never represented a person in a Wisconsin circuit court. She has never had a case in a Wisconsin circuit court. I have been in the courts representing people trying cases to a jury. My opponent has never tried a jury trial. I have argued the law. I have made evidentiary objections, and I've explained the law to real people, and that is one of the roles of a judge. I also have teaching experience. I've been an adjunct professor at the University of Wisconsin Law School for 12 years. I have taught trial advocacy, ethics, evidence, civil procedure, negotiations, and I co-founded the mock trial program in 2003, which teaches young lawyers how to be lawyers, how to practice by the rules of evidence, the rules of procedure, and the rules of law. Turning to my experience as a community leader, I have lived in, taught in, practiced in, and supported Dane County for 2 decades. I have volunteered for various, for example, I taught high school East High mock trial students for many years in the mock trial program, teaching 9th through 12th graders not only about trial practice, but about how to be confident and how to think about a situation from both sides. I still volunteer in that program, and in fact, I'm judging the competition at regionals this Saturday, and I've been asked by the State Bar of Wisconsin and the law school to write the 2014 National Mock Trial Problem for all of the students in the country. I also have given my time, I volunteered with the AIDS Network on the ACT ride. One year I rolled 1,200 burritos, I had some help. I also have delivered Meals on Wheels. I've donated my resources to the things that I believe in, Fair Wisconsin, AIDS Network, Goodman Center. I have given my time and resources to the people of Dane County my whole career. My judicial philosophy is simple. I believe that the judiciary is a check on the legislative and executive branch, and that the judicial branch derives its power from the Constitution. And that in looking at cases and looking at constitutional cases, you must look at individual rights and constitutional liberties each and every time you look at a law. I ask you to join Madison Teachers, Inc., the South Central Federation of Labor, Fair Wisconsin, U.S. Representative Mark Pocan, Dane County Executive Joe Parisi, and hundreds more in supporting me for my candidacy for Dane County Circuit Court.
Rhonda, if you'll keep the microphone for a second, and we've got some questions we're going to work through. We'll start with you. Dane County's become a lot more diverse since I was a little kid. We have a significant African-American population, significant Latino population, significant Hmong population, and we've done an incredibly lousy job of making sure that our judicial system and our legal system responds well to them. I think there's no question with the high level of minority incarceration. Is there anything that you as a judge can do to respond to that? And tell us a little bit about your approach to it.
This has been an ongoing problem for many years, as you just indicated, and in 2003, when the study was initially done, about half of all African-American young men in the system were either incarcerated or under supervision. A task force was put together to try to figure out why that was, and there were some recommendations made. And there were some recommendations implemented, but not surprisingly, those recommendations cost money, some of them, and some were put into place, but to my knowledge, there has not been any follow-up. So one thing we need to do is look at the steps that were taken, the recommendations by the task force, and see if they're working or not. I believe that as part of the justice system, I mean, unfortunately, as a judge, once someone's in your courtroom, they're already in the system. But I believe that in looking at implementing these programs, you have to look at how the arrest rates for arresting officers differ between whites and minorities, for example. How the DA sentences differently, and if the DA sentences differently, and how judges sentence differently. I'm sorry, DAs charge differently. So we cannot, though, look at our justice system in a vacuum. I believe that we need to look at all of the different groups that can help solve this problem, and I'm more than willing to be part of those groups. For example, it's not surprising that a number of the people in the system are high school dropouts. have AODA issues and probably live in poverty or unemployment. And I think that we need to look at this as a systemic problem, look at all of the resources, from parents to teachers to social workers to after-school programs, to embrace this concept of cradle to college and help these students get a leg up, and these young people get a leg up. And I'm committed to helping in whatever way I can in a way that I'm asked to do that.
Thank you, Attorney Lanford, and Judge St. John.
I'm very glad you asked this question. Addressing the racial disparity issue is one of the main reasons I wanted to be a judge, and my experience working in the abuse and neglect system, in the criminal justice system, gives me a good background for dealing with this issue. There's some terrible statistics. Attorney Lanford referred to some of them. Minorities make up 21% of the population from 10 to 17-year-olders in Wisconsin. They take up 60% of the juvenile people in juvenile confinement. We also know that black men are sentenced to prison at twice the rate of white people when it comes to drug-related offenses. So we definitely have a crisis on our hands. Circuit court judges are at the forefront of dealing with this issue. We sentence defendants, so we get to make a big call about who goes to prison and who doesn't. We also have a big ability to work on initiatives specifically designed to keep people out of confinement, to keep people on the streets and get the support they need not to be confined. As a circuit court judge, there's a number of things I'm doing to address the issue. Number one, I use the tools that circuit court judges have to keep people out of jail. I'm a strong advocate of diversion programs that address the underlying causes of crime, a lot of times mental health and drug addiction issues, while keeping people in the streets and in the community. I also, when appropriate, find people eligible for expungement of their records. That's a way when young offenders come into the system who have fairly lower level offenses, they can keep that off their record. Another thing I'm doing is working on broader initiatives. I'm involved in several domestic violence committees right now. And then a third thing, I'm reaching out to other community organizations. I realize that judges cannot be silos. The problems that I see in my courtroom don't start there, and the solutions can't end there. I'm working a lot with other organizations to come up with better solutions. I'm also working with organizations and being able to use my role as a judge as a platform for discussing how investing in our resources and our community is a criminal justice solution. Thank you.
Thank you, Judge. Keep the microphone.
Okay.
You were in D.C. before you came here?
I was.
So you were in the D.C. circuit?
I was in the D.C. circuit.
Just to give you a quick follow-up on that one, you probably saw a lot of minorities in the courts when you were there. And is there, and I don't want to take a lot of time, so I don't get fair to this, but does that give you some experience in going into this? Were there experiences from D.C. that might help you to work in this area more than, say, a lot of judges who have not had a lot of experience?
Definitely. I mean, I was in D.C. Circuit Court every day representing kids in the abuse and neglect system. And it was really going from working in the Circuit Court in D.C. and seeing those kids to working in the criminal justice system here, seeing how closely the lives of the criminal defendants track the lives of those kids in the abuse and neglect system, and wanting to be in a role where I could really make a difference and divert those kids from ending up as defendants that made me be a judge. So it has a huge impact on me.
Thank you. And just keep on here for a second. We got the next question, which may actually grow right out of that, is what were the most important cases you tried as a lawyer and why?
You know, I handled multiple cases involving abused and neglected kids in Washington, D.C., and I handled well over 200 appeals, largely involving the victimization of women and children as an attorney at the State Department of Justice. These were all extremely important cases. One case that really stands out in my mind is a case called State v. Marinez. It was a case that I took to the state Supreme Court. There was a 4-year-old girl who had been sexually assaulted by her stepfather. He'd also burned her hand so badly that they declubbed. That means all the skin came off. She had to be airlifted to the UW hospitals. Now, they do forensic interviews, videotaped interviews of young children, and frequently those are played in court. Well, she's a 4-year-old girl. She couldn't tell when exactly, date or time, that she'd been sexually assaulted. She could explain, however, that she was sexually assaulted before the hand burning happened, and police knew when that hand burning had happened because of the medical intervention that she needed. Now, in the videotaped interview, she used the hand burning, or they used the hand burning to pin down the time of the sexual assault. The Court of Appeals reversed the conviction, saying that all those mentions of the hand burning should have been redacted. That should not have come in. Well, I fought hard to petition that case, took the case to the Supreme Court, and I ended up winning the case. This was significant for several reasons. Number one, it was significant because it saved that child victim and her family from having to undergo another trial. It was significant, too, on a personal level. A lot of my colleagues were a little hesitant about taking the appeal at DOJ. I pushed hard to take it because I knew under the law, of my research of the law, that we had a good chance of winning. So it was just proof of my Moxy and independence of making a good legal decision. Finally, it was important because it really helped open the law and make it more accessible to children. Child witnesses are a lot different than adult witnesses. For one, they can't tell time. But if we want the justice system to really be all-inclusive, to cover everybody, to cover these children, we need to have those accommodations. So that case really stands out to me.
Thank you. And Attorney Lanford, same question, a case that, how are we doing here? A case that particularly stood out to you and why?
When I read this question, I read it to mean cases that I had tried in circuit court. And I have represented many people in circuit court and tried cases, 2 juries in circuit court. But as I thought about this question, one case stood out, and I wanted to tell you about it. It was a Dane County jury trial case. It was an elderly couple in their 80s who had been hit by a drunk driver, and the wife had a compression fracture in her back. Now, for those of you who know medicine, compression fractures, there's not a lot you can do for them. They don't heal very well, and they cause a lot of pain. They came to me, the offer from the insurance company basically told them that their lives had no value because they were old. And they came to me not because of the amount of the offer, but because of what the message that was communicated to them. It was about their dignity. It was about the fact that their last years of their lives together were taken away because of somebody else's harming them. I went into trial for them, and using their words and my words, I told the jury that their life had value. I talked to the jury about how they were unable to go to the farmer's market. They were vendors at the Wednesday farmer's market at Hilldale, and they would go and sell their vegetables, and how they couldn't do that together anymore, how they could not do anything really together that they used to. And the jury came back with a verdict that was about 6 times more than what the insurance company offered to them. They cried when that verdict came in, not because of the amount, but because the community told them that their lives did have value and that it did matter. And they did not have to accept what a company told them about their lives. And it's a significant case, in my view, because it reaffirmed why I do and did the kind of work that I do. Because I want people to have that access, and I want people to stand on equal footing in the courtroom. And as a judge, in my courtroom, everyone would come in and play by the same rules and stand on equal footing. That's the kind of trial lawyer I was. That is the kind of judge I would be.
Attorney Lanford, keep the microphone there for a sec. Just to follow up on that a little bit, you're a trial lawyer. And trial lawyers take quite a hit in our society, a lot of times.
Yes.
Why did you choose to go into trial law, particularly, of all the choices you could have gone into?
Well, I was drawn to the personal injury practice because of my upbringing. Because I wanted to help people in the system who did not have access. I had seen one too many times. A good example is when I was growing up, my house was foreclosed on. My parents, because my parents were uneducated, unsophisticated, signed a loan with a company with a very high interest rate, and they could not make the payments. And so I wanted to help people who maybe didn't have a $100,000 retainer to pay a lawyer.
Let's follow up on that. The next question that the folks from SPARC have developed is, and it goes very much into this area, please describe your most challenging experiences interacting with people who are different from you, socially, economically, and politically.
Well, it's interesting when I first read that question because given my background, I read it and thought probably the most challenging experiences I had were when I was a kid, living in poverty and dealing with people of different economic classes. But because of those experiences, I have a lot of friends who span many different economic classes, and I do not find my relationships with them challenging. In my mind, economic status is a surface issue. It does not go to people's character. In my practice, I've represented hundreds of clients across many different races, different religions, different economic classes. I've sat in the homes of people, their homes from mansions to trailers in the middle of a field, from affluent neighborhoods to struggling neighborhoods, and I have met with those people and I've represented those people and given each of them equal and good representation. When I thought about a challenging situation, actually what came to mind most recently was I was basically raised by a couple of teachers growing up. And one of them I still keep in contact with and have for many years. I call her every year on her birthday and visit her when I go up north. And we had a debate about politics, which was strange because I always saw her as a mother versus someone to talk to about politics. And I was surprised that we had differing views on some subjects. And what it taught me from those conversations, there were conversations over a period of time, over several, and a few Facebooks, believe it or not. I love it that I can talk to my teachers through Facebooks from high school. But what it taught me was that, it's okay for people to have different views on a wide range of subjects, and it does not mean that relationships have to end because you have disagreements. And we're still close, we have been close, and we still talk every year on her birthday.
Thank you. Judge St. John, same question. Challenges with people and folks that are different.
As a mother of 3 young children, I'm constantly confronted with trying to negotiate with them and their temperaments. And my answer about what's affected me or challenged me most is sort of similar. As a lawyer at the Children's Law Center, I represented a lot of preteens and teenagers. I was really committed to trying to get positive outcomes for them, but sometimes, and it was sometimes incredibly challenging to move forward when they made bad choices. And their making bad choices were sort of part of what happened. We know that adolescent brains are not as developed as much as adult brains, and that development, not even delay, but just reality, is compounded when children have suffered trauma and instability that affects their psychology, affects their way of relating with others, and affects their ability to bond with others. So one of the typical examples would be that we'd work really hard to get a good educational or family placement for these kids, and then they'd have some disruptive or outburst, and they'd end up, the placement would fall apart. So I was working hard to get positive outcomes, to get stability for these kids that so desperately needed it, but sometimes it didn't work out. We had to move forward and try to come up with another positive outcome, another good solution. Now, my understanding of working with adolescents and teenagers has proved invaluable on the bench. Many of the defendants who come before me are barely older, they're young adults, they're barely older than those kids I've represented in the abuse and neglect system, and many of them have been products of the abuse and neglect system as well. So my understanding of working with these kids and understanding what they're going for has made me a strong proponent of some of the things I was discussing earlier. Diversion programs to keep people out of the system, expungement, which can get people who succeed on probation from having a criminal record, and working with community partners, trying to come up with mentoring programs and other things to give people support to keep them out of the system. My philosophy really was summed up by Bill Clinton at Ed Koch's funeral. Bill Clinton quoted Ed Koch as saying, we need to give kids reasons to say yes, or things to say yes to, not just things to say no to. That's my approach as well.
Thank you, Judge St. John. And so now you two have both been such, genuinely impressive up here. I think people would agree. But on the chance that you have not convinced one another to vote for the other candidate, you have an opportunity here to make the case why people should vote for you or for your opponent. Judge St. John, take yours.
This race offers a very clear choice. People should support me because I'm doing a great job on the bench and I have really relevant experience and background for the job. Number one, I have judicial experience and my opponent does not. Now this is a particularly good point, I think, because my opponent said earlier that I haven't appeared in Dane County Circuit Court. In fact, I appear in Dane County Circuit Court every day. I've presided over jury trials, 4 already. I've disposed of over 600 matters, and I hear approximately 40 matters a week. So I have judicial experience, my opponent does not. Second, I have broader experience than my opponent. I've worked in civil, criminal, juvenile, and family law. My opponent has focused her career on civil law in one particular area of civil law, personal injury law. I also have more legal experience than my opponent. As we discussed, I appeared in circuit court. I've appeared in circuit court as a judge all the time now. I also appeared in circuit court all the time as an advocate for children in the abuse and neglect system. Records show, court records show that in the 5 years before I took the bench, I handled 147 cases as compared to my opponent's 47 cases. In 2012, my opponent is listed as record in just 1 case. I'm also the only candidate in this job who's dedicated her career to public service. I worked in the nonprofit, the Children's Law Center, and then I worked at for the state. I've also done extensive pro bono work on behalf of people with disabilities and for children when I had worked at a firm. I'm also the only candidate in this race who is limiting the amount of campaign contributions and the amount of special interest money I'll take. I think this is incredibly important because as all 4 of us have discussed tonight, the judiciary is an independent branch of government. It's important that people understand that, and that's one way to reflect that. Lastly, I'm endorsed by 34 judges compared to the 3 judges who've endorsed my opponent. This is important because judges presumably know best what makes a good judge. These judges have seen me in action and see that I'm a good judge.
Thank you, Judge St. John. Rhonda Lanford.
Instead of doing my standard stump speech, I'm going to address some issues and tell you that Judge St. John just brought up and talk to you about my experience. First of all, as a lawyer, she has never appeared as an attorney in Wisconsin Circuit Court. She had 147 appellate cases. Just because I'm not listed as an attorney of record does not mean I'm not in court. I was in court yesterday. I was in court 2 weeks ago arguing motions. So that is not an accurate count by any stretch. There's a difference between litigation and appellate work. You're right, I have no judicial experience, but prior to about 4 months ago, neither did my opponent. She also has no circuit court experience prior to being a judge. She also spent, according to her judicial application to Governor Walker, only 10% of her time in state court ever. Public service, I believe that my record shows that I am dedicated to public service, given the 12 years I've spent teaching for almost nothing at the law school, all of the time I've given to high school students in this county, all of the charities and organizations that I've devoted my time to over the past 20 years. Importantly, I believe that our judicial philosophies differ. I believe that the judiciary is a check and balance on the legislative and executive branches. My opponent, in her application to Governor Walker for this job, thought that the best case in the last 30 years was a case written by Justice Gableman, where Justice Gableman said that it was appropriate to limit the authority, to restrict the authority of the trial courts to act in the interest of justice. That is not my role as a judge. My role is to look at each case fairly, neutrally, independently, and every constitutional case with an eye toward individual rights and constitutional liberties. My opponent is right about one thing. There is a clear choice on April 2nd, and I ask you for your support and your vote.